correct?
Yes.
Okay, Judge, I have no further questions.
Mr. Rosé, I don't have, we discussed this exhibit was actually part of your filing for the pretrial memo. Are we admitting Exhibit A, Counsel?
Move to admit Exhibit A, yes, Your Honor.
Any objection, Ms. Balle? You've read it. We've gone through it all pretty closely. I think it matches what you think.
No, Your Honor. I would ask if counsel would agree if I can submit at our next hearing the district attorney's accounting along with this.
Well, the problem is you'd have to have the district attorney here to testify, right? That's the problem. Do you have them scheduled to
That takes
testify now?
a lot of red tape, Your Honor.
What was that?
That's a lot of red tape, Your Honor.
Okay, well, first of all I asked about the admission of this, and you say yes, admit it. You agree that that's their numbers, right?
Yes, that is their numbers, yes. But I do agree that those are with the misdemeanor dates, yes.
Okay, Exhibit A will be admitted. Counsel, anything else? You haven't shown me any exhibits yet that you were questioning Mr. Collins on other than that one. Is that correct, Counsel?
That's correct, Your Honor. Would you like me to go one by one down each order and every single?
No, Counsel. The orders are actually part of the court record. My only concern was bank. You said you referenced some bank statements. I'm just not sure about those, Counsel, because I'm not able to look at anything unless they're admitted.
Gotcha. Mr. Collins, directing your attention to Exhibit B.
Okay.
Can you tell me what these documents are?
Second. Exhibit B are the bank statements that I use in reference for all the payments listed in the schedule of arrears that I agree.
And again, Exhibit C, no, those were all orders. Exhibit B are the bank statements relied on. I have no further question, Your Honor. I'm hearing a really bad echo from everyone.
Let me have other people. I guess everybody else is muted. Counsel, you haven't asked me anything about it. I can't look at Exhibit B. What are we doing? You broke up. What'd you say?
I'm so sorry, Ms. Collins. This is a true and accurate copy of the bank statements. Is that correct?
Yes.
And this is a true and accurate copy of the statements that you received from Mr. Balle himself. Is that correct?
Yes.
And you verified all the dates and all the payments made directly from these statements. Is that correct?
Yes.
Move to admit, Judge.
Okay, Miss Balle, any objection to Exhibit B?
That is his records? No.
Okay, Exhibit B will be admitted. Thank you. Okay. No, you said no further questions, Mr. Rosé, regarding this for this witness?
That's correct, Judge.
Okay, thank you. Thank you for your testimony, Mr. Collins. Ms. Balle, we finished with Mr. Collins, and now I'm going to let you. You said you wanted to testify on this issue. That was the only witness on this issue. Is that right, Mr. Rosé?
That's correct, Judge.
Okay, Ms. Balle, now's your chance to testify as to what you believe that issue is. You can tell me anything you'd like, but understand I'm going to keep you narrow to this issue. Do not go off on tangents about Judge Potter or anybody else. I want to hear about whether you believe these numbers are accurate, that you went through, that he missed those payments that we said, that Mr. Collins said, and that I'm reviewing. That's what I need. Okay, ma'am?
Yes, Your Honor.
Okay, proceed, ma'am. Remember, you're under oath.
Okay. So in 2014, I filed in order to show cause because I was not receiving payment. It went to court, and it at that time my alimony and child support were my only source of income. They weren't being paid. It took quite a few months to get any of that straightened out, and I would just like to put on the court record, it caused me to lose education, my home, time with my children, and it's been a ripple effect from there. Those payments missed. He was ordered under affirmative obligation to give his true earnings, which we still have never got. He testified in court.
Hold on a minute. There's an objection. What did you say, Mr. Rosé? Your objection is?
None of this testimony is relevant for today's purposes, Judge.
All right, ma'am, tell me why these are relevant to today's purposes, because all you're telling me is how it affected you. I need to know, I've got listed on what he missed payment and what he didn't. So tell me what that is.
It is relevant to today's purposes because the defendant swore in court he was current in all of his payments.
Okay,
From
well, you'll have to question
2014
that. You'll have to question
forward.
him on that at that time. When you question him, you'll have to question him on that. I don't see that, ma'am. I can't hear you
It's
telling
in
me
the
what you
record.
say he said. You're telling me what you say he said to a court. That's not going to fly. So what else, ma'am,
It's
regarding
in
the
the
payments?
court records and minutes.
All right, ma'am, what about these
It's in the court
payments? The payments. Focus on the payments. I need you to focus.
Okay, the payments were not made. The defendant said he made them. It is relevant. And it's in the court minutes.
Okay,
And in
ma'am,
the court
move on
video.
to your next statement, because I don't think they denied, the witness didn't deny that they missed certain payments.
The defendant missed February, March, April, May, all the way through to the end of the year.
Of what year, please, ma'am?
2014.
Okay, I just need to know that we're on the same page. Okay, so you're saying February.
And as per
Okay.
the official court record, the defendant swore in court he was current after 2014. So the defendant misled the court in that aspect. Then he asked for a reduction in 2014 on child support and alimony. The alimony was denied, part of official court records. Child support, they temporarily was granted based on true earnings. The defendant was put under affirmative obligation to provide true earnings. That has still not been done.
Judge, again, I'm gonna have to-
Ma'am, I've let you go. I've got you. Let you go far afield, but I know what the orders are. The order was $870 from May 1, 2014, and the last payment of $870 was 4/1/2015. Then it went back up to $1160. So what else about that, ma'am? Move on.
Okay, moving on from there. Okay, I lost my train of thought. So those, moving on from those payments, there were then payments missed sporadically throughout from 2014 through to what Mr. Collins had testified that he had.
Made. I think we've already agreed to.
Counsel, let her go.
Okay,
I'm
hold
going to
on.
give her some leeway. Let her go. I
Hold
agree,
on.
ma'am, that he said that. What's your statement regarding it? That's what he said. He agreed.
My statement is this. Then we have the 2017 payments. The question here is, why were those payments missed? Why were they not
There's not a
addressed by the
question.
court
There's not a
earlier?
question. You are testifying. You're not doing questions. Right now you're
I
testifying.
am testifying that, Your Honor, I have had this particular subject put off for over 8 years.
Okay, ma'am. Well, I'm
So,
letting you have
in
your
8
chance.
years-
I see that. I see the amount of money that was paid on all those months. So what else do you want me to know about it, ma'am? I see what was missed and what wasn't. I think we all agree what was missed.
Okay, well, I don't know if I can say this, but I'm testifying to the fact that there were never any consequences for any of those missed payments at all to the defendant, and there should have been consequences. And those missed payments aren't just about money, Your Honor. They're about this whole case and the children and how our lives had to be. This has caused me a lot of damage in my life and my children. And I just want that in the court record, that these payments weren't just to live on. These destroyed future earnings, increase in earnings,
And again, Judge, I'm
education.
going to object.
Quality of life.
Ma'am, I've already heard that this affects other things. Please move on to another topic, please.
And I would ask that I do not have the district attorney's payments in front of me, but they should be part of the court record already. And I would ask if there are any records. I've never
Who are
seen
you
any
asking?
records.
You're not questioning somebody. You keep saying, I would ask. This is your time to testify. This is not your time to ask a question. To tell me what else I need to know. Do you
Okay,
believe
the district
Mr.
attorney-
Collins stated what he believed it was? You agreed with him. You went over the ones that you think he missed. It sounds like we're all in
And I'm
agreement.
going to say that the district attorney's accounting of this case,
And Judge, I'm
I'm
going
pretty
to
much
object. There's never been
coincides with what
Objection
Mr. Collins
sustained.
has said.
Objection sustained. Ma'am, I'm not going to hear what the district attorney would tell you. Objection sustained. Move on, because you don't have the district
All
attorney
right,
here.
here. I'm going to say I don't believe that those numbers include penalties and interest, so.
Okay, that's fair. I'll write that down. No, that this doesn't include penalties and interest. Okay. Anything else, ma'am?
Okay. Regarding the missed payments, no.
Okay,
Other than that, there was
we started with that.
there was no enforcement. Your Honor, there was no enforcement. The sanctions and the enforcement never happened by this court. They never enforced their orders. many times since I brought this subject up. So that I just want to put that on the record for you. Because there were specific sanctions that
Okay,
were
ma'am, I've heard
in
you
these
all
payments
about
for
this
those
issue.
days.
Ma'am, regarding this issue, I've heard you all on that. Anything else regarding this issue? Are you done on that issue? Because I'm going to turn it back over to Mr. Rizet as to any other final comments regarding this.
I consider the sanctions to be enforced against the defendant.
Okay, Mr. Rizet, her argument is pretty much what I've heard. The testimony on both sides is everybody knows that the number is as far as what the missed payments are. Her argument is there's no penalties or interest on this schedule. Counsel, why is there no penalties or interest on this schedule?
Judge, I would submit to you because there shouldn't be, because again, until essentially today, no one was actually aware that these errors were made and that there was actually any arrears. This matter was before the court and continued
Objection.
many times.
Ma'am, well, hold on. What's your objection? Ma'am, let him finish his statement. Then you'll have a chance to talk again. Okay? So just let him finish.
The issue of the order to show cause, again, that was filed in 2014, Judge, and the trial for the mess of a history that this case has, was continued so many times that there was never an actual adjudication, so my client would know what he owed, Judge. If you look at the schedule of arrears and look at the history of it, he began payment of any order that literally at the minute it came out of the judge's mouth. A lot of these orders weren't submitted to the court months later, yet he satisfied his obligation immediately. And again, the issue of arrears, while it was brought before the court's attention first in 2014, because of the nature of this case, there was just never an adjudication of it. This is not someone that's acting on bad faith. This is someone who's paid when he had a financial difficulty.
Ma'am, don't objection. This is just argument. This isn't him testifying, ma'am. This is, I said, give me your closing argument regarding this issue. So that's not a place to object, okay, ma'am? Go ahead.
Counsel is misleading the court.
Miss Balle, please wait till he's finished. I'll let you have a chance to say all that, okay? Go ahead.
And Judge, again, the admits that there were arrears. We've come up with what that figure is. This is the first time that any judge on this matter has actually paid close enough attention to the figures, Judge. You're the first one, and quite frankly, the first time I paid close enough attention to it was when I was preparing the witnesses. This is just not in bad faith. The delay is not caused by him. I would just submit to you there shouldn't be any penalties or interest on this.
Okay, Miss Balle, I'm going to hear from you. I'm nice and I let you have a chance to speak, but I already have a lot of ideas regarding this. Okay, so go ahead.
Okay, yes, there should be. As I said before, and it is relevant, he testified in court that he was current after 2014. He was well aware of this statement.
Okay, that's all. I don't hear a lot more regarding it, ma'am. I actually am prepared to rule on this issue already. Mr. Rizet, I don't.
So now you don't want me to tell you what I said.
If you listen to me for a minute, I'm just saying I think a lot of what you're saying is not necessary because I agree.
Mr. Rizet is misleading the court.
I agree with you on some of it. I'm saying I'm agreeing with you that I don't need to hear a lot about it because I am agreeing with you on a lot of this already. Okay? I'm just saying, look, I agree. You say that there's penalty and interest. I'm going to talk about which one I think are relevant and which ones are not. But anything else, you say it.
Okay, what about the defendant and counsel are misleading the court and blatantly lying?
Okay, well, I don't find them to be blatantly lying, counsel, ma'am. I don't find that to be the case. So, no attacks on
person. If you look at the court record, it's on record. He's testifying or saying that they never knew about this payment. That is not true. It is in multiple hearings. That's not true.
Okay, thank you. I have heard enough regarding it. Mr. Rizet, I don't think I'm going to make a ruling on that one issue. Regarding the remand, I've stated that I've set that aside. I'm going to address both of those issues and whether it should be as an order to show cause. Regarding it, do I think your client should know? You betcha. He had all those orders. He knew what they were. Even your firm knew what they were. Do I understand that nobody bothered to pay attention? Perhaps. I'm not going to throw aspersions on the previous courts, but I looked at them. I did the math, and I don't think it's an excuse. Not paying attention to the amount you owe. He knew he owed them. He knew they should have been. The question becomes, do I just do interest or do I do penalties and interest? Do I think it was blatant? No. Do I think he should have paid closer attention? Yes. Do I think everybody should have paid closer attention? Yes, Miss Balle actually wrote in her motion to set aside that those included child support, and nobody even bothered that when you did the opposition, counsel. So I am going to order that your client is to pay interest on that. I'm going to need a spreadsheet calculation regarding interest on every payment he missed, and we've already went through. Miss Balle was very clear when she cross-examined Mr. Collins of what they are. As far as penalties go, as far as child support goes, you know that there's no more penalties regarding that in the state of Nevada, and the court has discretion whether they think that they're warranted or whether they were blatant in this case. I do not necessarily think they were blatant. The problem they have is that these orders went up and down with the prior courts. I agree with Miss Balle as far as the fact that this judge ordered that and then they didn't enforce it. I agree with you, ma'am, regarding it, but I do not find it to be egregious in order to order penalties. However, I am ordering interest on this amount. If she had that money, she would have been able to make the interest, and it would have affected her life differently. So, counsel, I'm going to need a schedule of arrears with the interest added to it and submitted to my court. The arrears regarding it are $33,600 plus interest. Miss Balle, so I'm splitting the difference because I don't think it was egregious, but I think that you are entitled to the interest you would have missed according to the statute, ma'am. That addresses that issue.
Just for clarification, when would that interest start to accrue?
Counsel will accrue on every payment she missed. I'm going to need an actual spreadsheet that goes and gives interest on them as we normally would do. And I'm going to need that submitted to me before the end of this trial date. I know Mr. Collins, I'm sure, has got a lot of work to do. So regarding that amount, the fact that you came before the court and you all did it and you said that she owed him $6,000 when actually he owed her $30,000, the court finds that interest is warranted. And that resolves the remand and the arrears. And ma'am, I'm not going to do sanctions as to orders show cause against him regarding it. I don't think it was blatant, but I am certainly going to, he's going to pay the interest regarding that. Okay, ma'am? So that resolves that issue. Any other questions for me, ma'am, on that issue?
Yes, can I request permanent maintenance because of all this 8 years of this going on? I want to request permanent maintenance.
Let me go through and deal the rest of the order. No, you cannot request that. Let me tell you why. I actually went through Judge Potter's, in preparation for this, I went through Judge Potter's things that Judge Potter did. Hold on, I'm pulling out my notes. And that was also submitted in the exhibits that were filed with the 360-page filing on the opposition. Ma'am, do you remember the opposition that Mr. Rizet filed on your motion to set aside on the 60B? Do you remember that? It had all. It had. Let me tell you what it had. It had a whole bunch of stacked. It had a whole 360 pages, and of that, it had in it a transcript from the May 1, 2018 hearing before Judge Potter. Do you remember that?
May 1st, 2018?
Yep, May 1st, 2018. Do you remember that?
Judge Potter was not our judge in May of 2018.
Yes, he was. Right before you got...
No, he was not. No. He was taken out of department. We were switched in January of 2017.
Hold on, let me go pull up that motion. Hold on a minute. Let me pull it up for you, okay? So we can be on the same page. So I'll make sure that I've got the information because I want you to look at it.
And Judge, I just want to clarify while you're looking that up. Are you looking up the one that came directly from him from a July, and it came out in August of 2015?
Hold on a minute. Let me pull it up so we're on the same page, okay? I got to go back. Your guys' case is so old. I got to go back. Hold on a minute, okay? It will be in the opposition. It's attached to the opposition to set aside that was filed March 15th, 2019. I'm going to look at it. Maybe I just have the year wrong, ma'am. You guys have so many years. I'm just making sure I'm on the right page, okay? Hold on 1 second. I'm going to get to it. It is attached to that opposition, so everybody's on the same page, and it is transcript from May 1, says 2018, Exhibit J. Let's go to Exhibit J on that exhibit.
Is this May 2018?
Hold on. I'm looking. Let me get to it. I gotta scroll down, and it takes a little bit of time on this computer. So hold on a minute. Let me get to it. It's the May. It was with the the May 15, 2019 opposition that was filed. It's attached to that, ma'am.
Okay. Well, you're getting to the horse before the cart. You got to go back to 2015.
No. I'm not getting the cart. You're missing a point. Let me get to where I'm at. Okay. So hold on a minute. Let me get to it. It just takes a while. There's so many pages here I have to get to. Okay. It was from May 1st. I have the audio transcript from the court. It's actually a Depo International transcript from the court. It shows Exhibit J. Do you have a copy of that, ma'am?
Somewhere in here. I mean, I'll stipulate if you're telling me, Judge, that you were looking at it, that I have it here, okay? I will.
I have it here, and on there, Mr. Rizet, if you want to follow along, Judge Potter was the judge at this time. Let me look and make sure I got that right. Because you guys
No, he was not.
Hold on a minute. I'm telling you that I'm looking for it to make sure who was the judge. Because I'm telling you that all I saw was judge, and I might have made it as Potter, ma'am, but it's just, I'm just trying to see who signed it.
It was definitely not Potter.
Okay, hold on a minute. I'll go through to the May 1st, 2018 hearing on my screen, okay? I just want to make sure we're all on the same page. And it could be the other judge. You've had so many darn judges, I understand that it's kind of confusing. So, hold on one second. I'm looking, you were right. You are right. It was Judge Steele. It just says judge.
Yes,
and I've been looking at all the Judge Potter things. It was Judge Steele, okay? I'm looking
But
at
we have to look at Judge Potter's ruling first.
Ma'am, I don't have
They came
to. I
first.
don't have to because a lot of it's forestalled by this. So wait till you get to this page. Okay, so I'm telling you I'm reading the transcript from that. Mr. Rizet, are you with me on that transcript? Do you have that before you, counsel?
Judge, there are so many pleadings that I'm trying to look at it still.
Okay, well, I'm going to read it all to you guys. This was actually, it was before Judge Steele. You were right, ma'am. Like I said, you guys had so many darn judges involved. I'm making sure. But I'm reading the actual transcript. And I went through the transcript, and on page 19 of the transcript, this is what it says. You guys went through the math with the judge as far as this is what happened in that hearing. You talked about stuff being ceased, the alimony is going to cease, and this is what the judge said. This was when Mr. Day was present. Do you remember this hearing, ma'am? You had Mr. Day present.
Yes, Your Honor, I do.
Okay. See, I had to play catch up because you guys were all involved and I wasn't. So I went through this, and the judge went through the whole issue about the fact that when the alimony started, and that it was 5 years. 5 years it was going to be $4,000, and then 2 years it was going to be $3,000. Right, ma'am? That's what your original decree said. Is that right?
It was 5 years at four. It was 4 years at 4,000, 3 years at 3,000.
No. You got it backwards.
Oh, no, I'm sorry, I had that wrong. It was a total of 7 years, though, wasn't it? For sure.
Right.
Because
So
one of those years, Your Honor, was
Stop. Let me go through it.
payment for the business.
I've got
That
it
was
right,
the business.
ma'am. Let me. You were wrong. Let me tell you what it says. It said, Mr.
No,
Day was
it's-
asked. Hold on, I'm reading the transcript, ma'am. It said the court said, if I had to enforce this order right this second and say alimony shall be ordered for a period of 5 years, the sum of $4,000. After alimony for a period of 5 years, it shall be set at $3,000 for 2 more years. That's 7 years. And Mr. Day said, no, that's all I got. And the court said, that's all I got. And then Mr. Day says, oh, I get that, Judge. Okay, so 7 years. So we started with 7 years, correct? So, ma'am, your alimony ended 7 years after that alimony started, it ended. Do you agree with me?
Yes, that's what I was just trying to say, Your Honor.
Okay, I just want to make sure we're all on the same page, ma'am, because I know there's a lot of history. So when I look at the decree of
But
divorce...
I wanted to clarify, Judge, that one of those years was for the business.
Ma'am, that's not the
When we
point.
got
The point
divorced.
is, this is after on the decree of divorce. You guys had it looks like you have an evidentiary hearing on 11/19/2009, and that's where that order came from, right? So the decree started there.
Yes.
So you had 7 years from 2009. Can you do the math for me? What year would your alimony have ended, ma'am?
2016. It had to be paid all the payments in that time.
Ma'am, it doesn't.
You did it.
No. The alimony ended at that point. Period. It doesn't matter whether they were made or not. What matters is he would. This is what the court clarified for Mr. Day, because that was Mr. Day was making the argument you were making. The court was very
But Judge
clear.
Potter ordered.
Hold on. Let me finish. You'll understand what.
There's another order.
There's
There's another order.
Ma'am, but there's no extension of time. I double checked every order. It only gave you have 7 years. Period. And Judge Steele.
It was yet to be determined.
Stop interrupting me, please. So once you hear me out, you'll hear it all, and then you'll go, oh yeah, that's right. So just give me a minute. So in the order,
Sure.
in the order, it gave you alimony for 7 years. That's your term, was 7 years. Did it change up and down? You betcha. But actually, it only went down. It never went up. I agree. in here, Mr. Day said, the judge said, okay, so 7 years. And then Mr. Day said, the problem is he hasn't paid. And that's the argument you made, ma'am. And then the court was very clear. Yes, well, then that's in arrears. But it doesn't mean, and then he said, again, we'll talk about it, that it's going to keep going. She said, that's over. As of 2016, it was over. She made a clear ruling regarding that. And she said, the court, yeah, alimony is ceased at this time and point. That's on page 19. There is no future alimony due. There might be some alimony arrears. That's what she's talking about. So there's arrears, but there's no alimony. Your alimony did not get extended past that time, nor can it get extended now by law. Do you understand that, ma'am?
We never had an evidentiary hearing to determine that.
You did. You had an order, a decree of divorce from 2009 that showed where your time was. Nobody granted you any extension. Once it expired, it expired. You can't go back and say, but I want more. That's not how it works. Nevada law is very clear on that, okay? So there was no granting of that.
I want to clarify. The reason that we were in front of Judge Steele at this point was because the defendant asked for the reduction. Based on criminal activity to keep out of jail, can't do that. So we had an evidentiary hearing set to determine what his true earnings were. Nobody ever determined that.
This time, no, that's not what this order said. This order, the specific discussion regarding that hearing said, no, that alimony has ceased. Okay, no, I'm done with I know what the record is, ma'am. I just read it to you. So that your alimony has ceased. It is not going to be modified at this time. That time has sailed. The time that would have been for it to be requested to be modified had to be before 2016. That was not when it was requested. You requested this in this 2018 period, but you didn't request it extended. He requested it reduced. Nobody requested it extended, and now is not the time, and that's not properly before the court. So the court
we never had an evidentiary here. We never got to court
please don't interrupt
to do that.
Ma'am, nobody filed anything. That
For
ship
the
is
record,
sailed. That ship is sailed.
there was not.
Now, the hearing was really clear. May 1, 2018, Judge Steele said, it's over. Your alimony is already expired. Done. Finished. I'm making it clear that that's what the court finds too. I didn't find anything in the record that had anything that I could address today because it's not properly before me to move forward with more alimony. You said, can I request it? Your request orally today is denied, ma'am. So that's what I'm telling you on the alimony. But do I believe there's arrears? We've already talked about that. I agree there's arrears, and I agree there should be interest on those arrears. So that resolves that issue. That solves those two issues, and that closes the issue as to you're opening that up and the remand. Any other questions for the court on that issue?
No, Judge Sagan, if I may, for clarification, you would like for us prior to Friday to prepare another schedule of arrears that contemplates interest from the first time Mr. Balle missed a payment in 2014 to the present.
Right, exactly, because he should have been paying her and he's got to pay the interest that he missed. So that's what that is. So, okay, so that resolves that issue. Do you have any questions, Ms. Balle, now?
I do. I would like to ask for a subpoena of the district attorney's accounting.
Well, today's the day for you to bring trial, and that issue's already resolved. Your request is denied. This is the time set for trial. You had to bring everything for me today. All right, that'll resolve
everything
that
is in the court record, Your Honor. I brought it forward since 2014.
I asked you just to tell me anything you wanted or to bring any evidence. I gave you a chance to testify. That issue is done, and I've actually ruled on that issue. Mr. Rizet, we have the other issues before. That resolves that issue. The other issues I have before me to resolve are the child custody issues that we are going to do. You wanted it Friday, but I have you guys scheduled tomorrow as well. Is that not correct, Counsel?
We are scheduled for tomorrow as well, Judge, but I think if we could do everything just in one day starting Friday morning, I know you have it scheduled for a full day on Friday, that would be a little bit more convenient for the
witnesses. Ms. Balle, that's what we have left to do is to resolve the custody issue. Do you agree, ma'am? You don't have to like my rulings, but I've already ruled on the issue of the remand.
No, Your Honor, I'm not saying that. What I'm saying is, if this isn't as cut and dry as you're making it, because what about all of the? I mean, I don't know what I have to do here because his non-payments also affected my credit. Everything, late payments.
Yep, I'm sure it did. I'm sure it did. It affects most people's all of that.
So I want compensation for that.
Okay, well, your
and
request
this court
is
is negligent in its duties to enforce. And nobody's going back and looking at the rulings that got us to Judge Steele. Judge Steele inherited this from Department M. And nobody's going back and looking at all
Ma'am,
of this.
I looked at them.
I get
I
what
looked
his
at
lawyer
them.
is
In
doing.
fact, I even read you the minutes from Judge Potter's order.
Then what about the order to show cause against the defendant?
Okay,
That's
well,
why we
ma'am,
were in front of
I've
Judge
ruled
Steele
on
to begin
both of
with.
those. Ma'am, I've ruled on both of those. I'm finding him that he has arrears in the amount of $33,600 plus interest. I'm not sanctioning him further than that. I'm not putting him in jail regarding it. I don't think it was malicious.
He lied to the court.
Ma'am, I've ruled on that. Anything
You
else?
were
I asked
right.
you what other issues besides child custody do you believe we have to finish? I'm trying to find out time schedule.
The financial, okay, the order to show cause and the sanctions against him, the accountability against him,
I've
which
ruled
has
on that.
caused
I've ruled
all
on
of this
that. I've
snowball.
ruled on that. I've ruled on that. What else? Ma'am,
You,
I've ruled
okay,
on
what was
that.
your ruling on that? Clarify, please. Clarify your ruling, please.
I said regarding the order to show cause, I am finding that he was in arrears at that amount. I do find that the mistake wasn't intentional or withholding. It wasn't willful under the law. It would have to be willful. I don't find it willful, but I am finding that there is arrears in the amount of $33,600, and they're going to be reduced to judgment, including interest. They're going to be payable. Mr. Rizet, I'm going to make him payable at the amount of $2,500 per month.
Hey, hold on, Your Honor. I have an objection to that number.
Okay, tell me your
Is
objection.
anybody hearing me?
Go ahead. The court. Tell me what your objection is.
Okay, first of all, it should have been, okay, so I'm looking, the interest as of 2016 was
No, ma'am, I haven't made a
$11,700.
rule. I haven't set the interest. They're going to have to provide me with a schedule of arrears, including interest, and then we'll talk about the interest amount.
I'm looking at an audit summary given to the court from the district attorney that I submitted.
Well, I've made a ruling of what the arrears are because by your own testimony, what payments he missed, ma'am.
Okay.
I don't have the district attorney before me. You didn't call them as witnesses.
But what I have
made
an
a ruling
objection
on that.
to is that he willfully did not do it. He willfully did it.
Well, the court is making a
And
finding.
he was
I've
hiding
already made
assets.
my
That was
ma'am.
never...
Ma'am, I have to make that finding. You don't get to make that finding. The court does not make such finding. The court does not find it willful. The court finds it was
And I just asked that the
ridiculous.
court look at what... I just asked that the court look at the court record from the first time this OSC was filed. That's all I'm asking.
Ma'am,
Not to when
I
Judge
went
Steele got
through
it.
all of those. That's how I originally found that you were right about the 840 was actually put in as alimony when it was really a child support reduction, ma'am. I really went through all this. So that is my ruling.
I'm looking
I
at
don't
the
find it to be.
order
I don't
for
find.
minutes.
I would have to make a finding that it was willful. The court is not making any finding that it was willful by Mr. Balle. Do I think it was?
I'm going to read from the minutes, Your Honor, to prove that he willfully did this.
Okay, well, ma'am, I asked you if
He
there was
admitted
anything
to
else
it.
you wanted to testify as to that or anybody else you wanted to call, and you said no, so I've already taken the testimony on that. That part is resolved. Mr. Rizet, I show that to be the case. Miss Balle, this is what I'm
Yeah,
going
I
to order.
object.
You said to me you had a dispute regarding the amount per month he's going to pay, ma'am. What's your dispute? You didn't finish your statement.
My dispute is I'm even looking at the court minutes. From
Your dispute
7/27.
was that I said he will start paying you $2,500 a month towards that arrears. So you said you object to that amount. I said, what's your objection? What's your objection? You didn't say anything. Tell me what your objection to that amount per month is.
It's nothing to the decree of divorce. That is correct. That amount is correct.
Ma'am, you said, when I
What?
said I'm going to order him to pay the arrears in the amount of $2,500 per month, you said I object to that amount, the $2,500 a month
No, I
payments
was
towards arrears.
I was talking about the total amount
Okay.
that he owes me because it should have
Well,
penalties
you
and
can
interest on
object to
it.
it. I've already made a ruling as to interest. I don't know what the amount's going to be. We'll see it on the schedule, and I'll determine if the schedule is accurate on Friday, ma'am. So that was my ruling regarding that. Regarding that, but my question was, my ruling's going to be $2,500 a month. That wasn't what you're objecting to. Evidently, you misunderstood what I was saying.
No, that was not, Your Honor. I'm sorry. Clarify.
That's fine. That's fine. So it'll be $2,500 a month, beginning the first payment April 1st. Well, no, we're going to do it in two. Are you going to do it in two payments, Mr. Balle, or are you going to do it in one?
Yeah, I can do it in one.
Okay, then I'm going to say the first payment's going to be due March 15th. We're going to do the 15th of every month. Does that work for you, Miss Balle?
Sure.
Okay, 15th of the month will be the amount. I just don't know what the total is when you add the interest, ma'am. So we will determine that on Friday.
But, Your Honor, I would like to bring this up to you, please. Now, this is just for alimony. We haven't discussed the child support, correct?
No, we did discuss both of them. We went through both. We went through the statement that had all of it. Which child support payments he missed, which ones he short.
Okay, so listen, Your Honor. Okay, then there is a problem with the child support amount. At the time, he got the reduction, and I'm going to read directly from an order. This is an order.
No, I already ruled on that
522.
issue. I'm not opening that back up for discussion. I've already made a ruling on that issue. On the next issue, let's talk about our
It was
schedule.
already an order. You can't
I've already
overturn
made a
another
ruling
order.
regarding it. I'm not changing the orders. They're on the schedule of arrears. Ma'am, maybe you need to look at that schedule of arrears that you were thinking. You can actually, we'll talk about it a little more on Friday, but only as to...
But, Your Honor,
Ma'am, you need to
the
look at it.
court...
You need to look at it.
No,
I'm not
they
gonna
have
interrupt you.
we don't know what his true earnings were on child support, is my point.
I don't have to go revise it.
he
Ma'am,
never
I'm not
reported it.
retroactively revising his child support. It was set by order. Those are the orders. I'm not going back and revising those.
Okay, so
I
can
don't
you
have the,
clarify?
I don't have the ability. Let me tell you, ma'am, under the law, I don't
Okay.
have the ability to go retroactively modify child support. I don't have the ability to do that. Okay?
Okay, because I'm looking at an order where they did it, so that's why it's
Well, he
asking.
did it retroactive to the date of the original filing of a motion, not an order to show cause, not of that. That had to do with modification.
No, I'm reading from an order, not
I
an
know,
order
but
to
it was
show cause.
the only way you can go retroactive is to when there's a request, a motion to modify child support. You can only go back to that motion. That's what they're talking about. You can't go back and just make it up and say, now prove what you made back then. So, ma'am, I've ruled on that.
No,
I'm
this
not-
is an order. It's
Ma'am,
already
I'm
yours.
not retroactively modifying child support back at all. So that's resolved. Mr. Rizet, your question was whether we could do this all on Friday.
I'm going to
Miss Balle,
to that is a possibility.
well, that's fine, ma'am. You're welcome. You have whatever remedy you'd like to take. I've made a finding regarding it, and the court cannot retroactively go determine what his child support should have been way back then. That was for it to be set previously.
Well, if they can, if they never heard the case.
Ma'am, I'm not going to
It's never been heard or investigated.
I'm not addressing this issue anymore. We've already addressed it. Mr. Rizet, let's talk about trial. We did have it scheduled for half day tomorrow, but if we only have child support or child custody to go, I normally do those in less than one day, but usually half a day. One day will probably be sufficient. Ma'am, do you believe there's anything else? I'm not going back on what we just talked about. Any new item that I have missed? I show custody as the last item for us to resolve. Is that what you agree with, ma'am?
I agree custody needs to be resolved. However, I'm going to say this again to the court.
Again,
You
if you're
guys
going to
have
repeat
got to go
yourself,
back
I'm
and
asking
deal
you.
with
I'm
what the
striking your
court denied.
statement, ma'am. I'm striking your statement. I've already heard that repeated. You're not going to repeat it to me. I heard you. I've made my ruling.
It's like
That
you're
is
blaming the
final. Ma'am,
person
that
that
is
hit by a
final.
drunk driver for hitting somebody else.
Ma'am,
Okay.
my ruling is final. You're saying things that are not relevant to this case or the matters before me. So that will be what we will hear this on Friday, Counsel, at 9 a.m. You are all going to be in person. I'm not doing this on the screen, especially not with Miss Balle unable to do it. Everybody will be in my court, courtroom 3, 3rd floor, in person, 9 a.m. on time. Any other questions?
No, Judge.
No, Your Honor.
All right, Mr. Rizet, I expect that filed by the close of business tomorrow, so I could review it before 9 o'clock in the morning, Counsel. Because you know me, you know I'm a math nerd. I get out the calculator and I go down the stuff because I'm a math nerd. So I will see you all here on Friday at 9 a.m. Thank you for your appearances.
Thank you, Judge.
Thank you, Judge.